Due Process, winner of 21 regional Emmy Awards, including the 2010 New York Emmy for our coverage of voting rights and the 2012 Mid-Atlantic Emmys for Outstanding Interview Special and Outstanding Discussion Series. Due Process is a presentation of Rutgers School of Law, Newark, and the Edward J. Blaustein School of Planning and Public Policy. Studio facilities provided by the Rutgers ITV Studio, Division of Continuing Studies.
I deserve full equality! Full equality! Right here! Right now! Right now!
Equality in marriage.
You are married.
Just one of the items on this High Court calendar. Just one online for decision before the U.S. Supreme Court ends its session in June.
No, you don't have to beat us!
Issues ranging from continuation of the Voting Rights Act to affirmative action in college admissions. The ACLU with a role in each. Its legal director, Steve Shapiro, here to walk us through them all on this edition of Due Process.
Major funding for Due Process provided by the Fund for New Jersey, supporting informed citizens for an effective democracy.
Full marriage equality. It could come one step closer in this Supreme Court session, but that's not the only case on the calendar. The court will deal, too, with a range of issues from voting rights and affirmative action to the right to remain silent. I'm Raymond Brown.
I'm Sandra King, and welcome to the annual Due Process Court Roundup. A look at what made it to the docket and what didn't. What cases are pending and what they could mean. Will the court make history again this session, as it did last year, on health care?
Those questions and more for our favorite court watcher. Steve Shapiro is legal director for the National ACLU, not a neutral party in these matters, but we count on Steve each year to bring us his side and the other side too. Steve, thanks for returning.
Always a pleasure to be here.
And indeed, you are either a friend of the court status through the ACLU or actual counsel in many of the cases we're discussing this year.
Yeah, about a quarter of the court's docket, I think.
That's significant. The case I want to start with is one that resonates because we've just moved out of one political season, although we'll be soon marching to another, and lots of discourse about voter suppression around the country. But the Supreme Court is now granted cert to a case involving the Voting Rights Act, which was passed in '65, amended in 2006, and a county in Alabama is saying, wait a minute, why are we still in a position where much of what happens to us procedurally is being dictated by events long ago? What's that case about, and why is the court hearing it?
Well, as you say, the Voting Rights Act was adopted by Congress in 1965. I think most people would say, I would say, it's probably the single most successful piece of civil rights legislation this country has ever enacted. It has made an enormous difference in the ability of racial and language minorities to participate fully in the political life of this country. But it is still an unfinished story and only a partial success. And there are two critical provisions of the Voting Rights Act. Section 2 of the Voting Rights Act prohibits voting discrimination. If a local jurisdiction, state or local jurisdiction, engages in voting discrimination, they can be sued for an injunction to block the voting discrimination from continuing in effect. But in addition, Congress in 1965 said there are certain states and jurisdictions that have such a history, not only of voting discrimination, but of circumventing and evading judicial efforts to correct that voting discrimination, that before they can change their voting rules or procedures, they must submit those changes to the federal government for what is known as pre-clearance.
And of course, that challenge is not new. We've seen that before the court.
And that challenge is not new. That is Section 5. It was originally enacted for 5 years. It was then reauthorized in 1970, reauthorized again in 1975, reauthorized again in 1982, and then most recently reauthorized in 2006. And the reauthorization in 2006 was quite interesting. There was because the The same claim was made then as the challenges are now making before the Supreme Court, and that was, this is an historic relic, it's addressing a problem of the past, it's time to release us from this obligation of having to submit our laws to the government for pre-clearance. And Congress compiled a voluminous record, 15,000 pages of legislative history, 90 witnesses, I think 20 congressional hearings. And Congress came to the conclusion that despite all the achievements of the Voting Rights Act, in fact, voting discrimination remains very much a modern day problem, and the jurisdictions that have historically been covered by Section 5 of the Voting Rights Act remain the worst offenders. And so the reauthorization in 2006 was approved unanimously by the United States Senate. In the House of Representatives, it was near unanimous. I think the vote was 380 to 43 or something like that, and signed into law by President Bush. So it was truly a bipartisan conclusion that the need continues and that Section 5 of the Voting Rights Act in particular is an effective remedy to try to halt the ongoing voting discrimination that we still live with in this country.
Now, what kinds of things are the states covered by the Act looking to do that makes them want to avoid the pre-clearance process? What, on the ground, concrete things are they?
Well, all you have to do is look at the last election. I think you get a sense of a menu of what came to be known as voter suppression devices. The requirement of producing a photo ID was one. The elimination of early voting hours was another. There are changes in the rules for absentee ballots, changes in where voting precincts are located. Those are the kinds of things that can be used and have historically been used to disenfranchise people and to disenfranchise racial minorities.
Now, the other side is saying, look, you're seeing an emergence of a growing number of black and other minority candidates and successful people seeking office in these states. Why isn't that enough? That's really the argument on the other side.
Well, that's the argument. We have an African-American president. We must therefore have conquered the problems of racial discrimination in America. And I think it's terrific that we have an African-American president. It's terrific that we have more African and Hispanic elected officials than we have had in the past. But they are still vastly underrepresented in terms of their percentage in the population. And we still live in a country where voting is largely racially polarized.
But the argument is also, Steve, that these things don't just happen in the South. They don't just happen in the places that were most historically egregious. And therefore, this rule is really outdated.
Well,
Any truth to that? We know, we've seen it happen in Jersey City.
There's half truth to it, which is that voting discrimination occurs throughout the country, not only in the so-called covered jurisdiction. But what those 15,000 pages of legislative history documented, and I think really beyond dispute, is that the worst problems occur in historically covered jurisdictions. Something like 80% of the successful voting discrimination lawsuits over the last generation have been brought in the covered jurisdictions, which have only 25% of the nation's populations. So sure, we have to worry about voting discrimination everywhere, but this is a law that focuses on the places that have not only historically been the worst, but remain the worst offenders.
So listening to you, I think our viewers might well say, wow, this is something very serious, a lot at stake here, and yet there is an argument even on the progressive side that says, hey, don't get so worked up over Section 5. Section 2 really does take care of it. And besides, the most serious problem is not requiring somebody to have a picture ID for voting. The most serious problem is the gerrymandering in the drawing of districts.
Well, I think they are both problems, but new voting districts need to be submitted for pre-clearance as well under Section 5 if you are a covered jurisdiction. And the difference between Section 2 and Section 5 is, in order to bring a Section 2 lawsuit, the burden is on the discriminated against voter. You have to find a lawyer, you have to go to court, you have to bring a lawsuit which is expensive and time-consuming and often difficult to win and may take years before you can prevail in court. Section 5 is a quick, easy administrative remedy, and the Justice Department serves as the first filter in determining what is a discriminatory voting practice and what is not. And the vast majority of voting changes that are submitted to the Justice Department are, in fact, pre-cleared. The ones that the Justice Department objects to are the ones where there is a strong reason to believe that the proposed proposed change in voting rules either was enacted with a discriminatory purpose or will have a discriminatory effect. And those laws ought not to be allowed to go into effect, and Section 5 has worked very well.
Before we leave the voting rights issue, let me draw you a little bit out of your professorial neutral role and ask you one question as an advocate. Are you concerned at all about the current composition of the court with respect to this issue?
Yes, because there was another case before the court several years ago out of Texas in which this issue was also raised. The court found a way to avoid answering it, found another way to resolve the case. But in the course...
But left Section 5 intact.
It left Section 5 intact, but in the course of its opinion, written by Chief Justice Roberts, the court expressed serious questions about the ongoing constitutionality of Section 5, and it was that invitation to come back to the court that I think encouraged Shelby County and other jurisdictions. Shelby is just the one that has reached the Supreme Court to bring this lawsuit, and so we will see. But I think it really is important to recognize that if the court were to strike down Section 5, which could happen, they really would be removing one of the sort of pillars of the civil rights era in the United States. It would be a big deal if Section 5 were struck down.
You know, we always wonder how many people are paying attention to something like what cases are before the court, and I suspect that many fewer than are paying attention to who's next on American Idol. Right. But those who are looking are surely looking less at voting rights than at gay marriage. We have two cases that are coming before the court, and I wonder if you think that these will be the definitive judgment on gay marriage for this country, or is this just another step in the battle for marriage equality?
It could be the definitive step. The court could. There are two cases. They raise related but really very different issues.
Let's talk about the DOMA first.
Yeah, DOMA is a federal law. The initials stand for the Defense of Marriage Act. Adopted by
Passed under Bill Clinton.
Adopted by Congress in 1996, signed by President Clinton at the time, that says whether or not the state in which you live recognizes you as marriage, for all federal purposes, the federal government only recognizes a marriage between a man and a woman. So if you live now in New York, or you live in Connecticut, or you live in a host of other states that now recognize same-sex marriage, you still are treated by the federal government as though you are unmarried. And that statute has been challenged as a violation of equal protection, a violation of basic fairness. And if I could, in 2 minutes, to tell the story of our client in this case, because we are co-counsel in the case that is before the Supreme Court. The name of the case is called United States versus Edith Windsor. Edie Windsor is now a woman in her 80s. In the 1960s, she came to New York. She met a woman named Thea Spire. They started to go out, and several years after they began a relationship, they actually got engaged at a time when it was inconceivable that they would ever have the possibility of marrying each other. It was a gesture to each other, the seriousness of their relationship. 10 years into the relationship or something like that, Thea gets diagnosed with multiple sclerosis, right? For a while it's in remission, then she starts to, her health starts to deteriorate. And finally in 2007, 40 years into this relationship, she turns around to Edie Windsor and says, would you still like to marry me? And Edie says, yes. They get married. 2 years later, she dies. Like many couples in New York, they're not a wealthy couple. They have two principal assets. They own an apartment in New York that they have lived in forever, and they have a small little house, out in the country. Thea, who has died, leaves her entire estate, meaning her share in the two houses, to Edie. Had they been husband and wife, there would have been no tax associated with that bequest because there's a marital exemption. You don't have to pay tax on what your husband or wife leaves to you if you're a heterosexual couple. Because they were a same-sex couple legally married in New York, however, the federal government didn't recognize their marriage, and they gave Edie a $363,000 tax bill, which she paid, and then went to court to sue to get it back. And what she says so movingly is, she says, it's not about the money. The money matters to me. I'm not a rich woman. The money matters. What really offended me was this is the was my life partner. This was the love of my life. She died after we were together for 42 years, and my government came in and treated us as though we were total strangers to each other, and that ought not to happen in America. That's the issue in the DOMA case. And if we win in the DOMA challenge, which I am optimistic we will, it will not require any state that doesn't yet recognize gay marriage to recognize gay marriage, but it will require the federal government to recognize gay marriage in every state that recognizes gay marriage. Because I think there is no justification for the federal government refusing to accept the state's definition of marriage. Marriage has traditionally been a state prerogative. States determine who can get married. The federal government has always accepted the state's definition of who is married and who is not married.
You're comfortable that even the conservative wing of the court may be comfortable because of the reason.
Well, there's a funny states' rights issue and equality issue that come together here, and I think the moment has just come. The last four states, the last four courts, including the court in the Edie Windsor case that ruled on the constitutionality of the Defense of Marriage Act, have all declared it to be unconstitutional. I'm hopeful that the Supreme Court will do that as well. The Proposition 8 case from California raises a different issue, because there the claim is not that the federal government has to recognize marriages that the state already recognizes, but that the federal Constitution requires the state to recognize same-sex marriage even if it has chosen not to.
Big one.
It is, well, they're both big, but the California case is the case that could definitively resolve the gay marriage question if the court rules, as the lower court ruled, that the denial of same-sex marriage is a violation of the federal Constitution. Now, having said that, there are a variety of ways that the court could rule in the California case, even if it believed, right, that some denials of same-sex marriage violate the Constitution. So it could rule, and this is what the lower court ruled, that because of the peculiar circumstances in California, right, it was unconstitutional for California to deny same-sex marriage when it allowed opposite-sex couples to marry, because under California law, same-sex couples have all the same rights and responsibilities as married couples. They were, for a period of time, allowed to marry in California, and then the state reversed its position and took it away. And there is no very good, easy way to explain why the state would say same-sex couples have all the same rights and responsibilities.
And then we've got a limited effect.
All we're denying is the name. That just looks like hostility to gays. That's illegitimate, right? Then we have a California solution, right? There's another way of looking at this that would affect 8 or 9 states, and then there's what people are referring to as the 50-state solution, which would end the ballgame and say, just as the court said in the 1960s when it ruled that the Constitution forbid laws, state laws that prohibited interracial marriages in Loving versus Virginia, once the court ruled that was over in every state of the country, there could be a decision like that from the Supreme Court. We will see.
Steve, there's been a sea change in the attitude toward same-sex couples in this last decade. I am sure that Hillary Clinton is sorry that Bill signed that legislation, and I suspect that he is as well. But things have changed. The question is, have they changed enough on the court? And with the split being what it is, do you see the 4-4-1 dynamic here, or do you think this court might actually say, well, things are different, and we're going to take a different kind of move?
I think Justice Kennedy remains a pretty critical vote on the gay marriage cases. He has written all of the major gay marriage decisions from the Supreme Court in the last decade. He wrote Lawrence versus Texas, which struck down the consensual sodomy law. He wrote a case called Romer versus Colorado, which said you couldn't make it more difficult to protect gays and lesbians from discrimination than you make it for other people to be protected from discrimination.
But isn't there a jump from that to marriage?
Well, there is a jump from that to marriage, or there may be a jump from that to marriage, but it reinforces the view that I think he becomes the pivot on which the court is likely to decide this case. And we'll see whether he thinks it's a big jump or not.
So Roberts is not going to carry the banner on this one.
I think all eyes are going to be focused on Justice Kennedy. Now, I should just say, without getting too complicated here, when the court agreed to accept both of these cases, the DOMA case and the California marriage case, the court said there are some preliminary issues that we would have to decide about. We would like you to brief, and we will have to decide about whether or not these cases are even properly before us. So it could be either for technical reasons or because they can't reach consensus and don't want to have a fractured decision on something so important that they could duck a decision in either or both cases.
Let me mention another case where the court might find the technical out and also will test this paroxysm of optimism you seem to be experiencing here today.
Isn't that wonderful?
It is.
Yeah, right.
But,
after all these years, still an optimist, yeah.
Fisher versus Texas,
Right.
which is affirmative action, higher education, again. With a different court and with one Justice recusing. So what do you think is going to happen? What's the issue and how do you think it's going to be presented?
The issue in the case is to what degree a University of Texas can take the race of its applicants into account as one factor among many in deciding who gets admitted to the university, and more specifically
but that
to the
far,
flagship.
it's
Right.
no new ground. That's
Well, what makes
settled.
it's no new ground because back in 2004, maybe, I don't know, the court decided it's an affirmative action case from the University of Michigan. And they said as long as race is only one factor, you don't have a quota, you're allowed to take into account the race of the students because the university has, what the court said was a compelling interest in putting together a diverse student body because it benefits everybody to go to a diverse university. What makes the University of Texas a little bit different is that the University of Texas also has something called the 10% plan. And under the 10% plan, the top 10% of every high school graduating class in Texas gets to go to the campus of the state system of their choosing. And that 10% rule has produced a certain amount of diversity, largely because high schools are segregated in Texas. So you have this very funny outcome in where the integration at the university level is premised on segregation at the secondary level. But it nonetheless has produced, a student body at University of Texas at Austin, which is something like 22% of
There's
minority
also a critical
students, right?
mass concept that's a kind of new idea.
Well, there's a question of how much is enough, right?
Right.
And so what they did was they had this 10% rule, and then they added on top of it, and they said, we also, though, for the something like 75% of the class gets chosen by the 10% rule. They said for the 25% rule, we're going to take race into account in deciding who to admit, or not as a quota, but as a factor.
So how does this one go?
I think it's going to be very tight. I think it's going to be a very tight case in the Supreme Court. And again, I think a lot of this turns on Justice Kennedy because Justice O'Connor wrote the opinion in the Michigan case. She has obviously retired from the bench. She's been replaced by Justice Alito, who I think is going to be less sympathetic. Justice Kennedy dissented in the Michigan case, but he also, I think, has respect for the court's precedents, and I think he really does understand the importance of diversity and the ongoing problem of race discrimination. So,
And there's a slimmer of a standing issue, maybe.
do
Do the plaintiffs who wouldn't have been admitted have standing, the right to be in the court?
Right. There's one woman who brought this lawsuit, and she's now out of college, right? And so the question is, what's her stake in this controversy? And the court could ultimately decide none, and then dismiss the case. My guess is they're going to go on and reach the merits, and either it's like marriage. There are a lot of way stations before you get to the final terminal, and they could just uphold the Texas plan,
It's a
or
puzzling metaphor.
Yeah, is it right? I took the train out here, Raymond. But they could just say, what Texas is doing is fine. It's not much different than what we approved in Michigan. Go forth and continue. Or they could say, you have a particular set of procedures and it's that combination of procedures that's unconstitutional. But what Michigan does remains constitutional, and we'll see.
So we've touched 4 out of 74.
Yeah.
Let me just ask you, with about 45 seconds remaining, a minute remaining, talk about the right to remain silent case,
Right.
because most people probably think, well, that's long ago settled, and yet there is a nuance here.
The right to remain silent means, the court has said, that if you refuse to testify in a criminal trial, the prosecution cannot stand up and tell the jury that you refuse to testify and use that as evidence of your guilt by saying, well, any innocent person would have told his side of the story. He must be guilty because he didn't testify. You have a right not to testify, and that silence cannot be used against you. The question in this case is what happens when that exchange takes place, not at trial, but before you're even arrested. The police are investigating a crime. They come to your house.
You say, I'm not going to answer.
Where are you on Thursday night? You say, I'm not going to answer, and then the cop shows up in court and says, I asked him the question he wouldn't answer. Is that
So
a
now you're at
penalty on your
trial,
right to...
and that is being held up as as reason to believe in your guilt.
Right, and the question is that a penalty on your right not to incriminate yourself? And I think it is, and I'm hopeful the court will say that it is.
Hopeful, or you think it's going to happen?
Hopeful.
And that's where we have to stop for now. But with our thanks, Steve, as always, and our thanks to all of you for watching this special Supreme Court edition of Due Process.
What you need to know about what impacts your life. It's why we're here. So we hope you'll join us next week and every week. And visit our website at dueprocesstv.rutgers.edu, where you'll find all 17 years of our award-winning program. For Sandy and all of us at Due Process, I'm Raymond Brown. We'll see you next time.
Because it is legal and official to do so by the power invested in me in the state of New York, but most especially because it's always been God's vision to be where love is, and therefore God is here. It's my deep honor on behalf of all of our clergy staff to pronounce that you are married and to ask you to salute your partner, honey.
Want even more insight on law and justice? Become a fan of Due Process on Facebook. Follow us on Twitter and watch us on demand on YouTube.